I'm Mike Hackard with Hackard Law. You might think a carefully written trust or will is enough to protect your estate. You've signed the documents, met with an attorney, maybe even talked it over with your family. But what if I told you that a single outdated form or an account left outside your trust could undo everything? Today, I want to talk about the silent killer in estate planning: outdated beneficiary designations and uncoordinated assets. These oversights can derail your entire plan, cause bitter disputes, and leave your loved ones facing legal chaos at the worst possible time. What are beneficiary designations? A beneficiary designation is simple. It's a form, a line you fill out when you open a life insurance policy, a 401k, or even a bank account. It tells the institution who gets the money when you die. And here's the kicker: it overrides your will or trust. Let's say your trust says everything goes to your children, but your old life insurance form still names your ex spouse. Guess who gets the payout? We've seen it happen again and again. Why these mistakes are so dangerous. Most people forget these forms even exist. They fill them out once, maybe 20 years ago, and never update them again. Then life changes: divorce, a second marriage, the birth of a child, a falling out with a relative. But the paperwork, it stays frozen in time. That's how we see heartbreaking situations like these. A former spouse inherits a six-figure insurance policy. A grandchild is unintentionally left out. A carefully crafted trust is completely bypassed. And in California, beneficiary forms usually win, even when they conflict with your will or trust. Uncoordinated assets, the hidden threat. Now let's talk about uncoordinated assets, things that aren't properly titled or aligned with your estate plan. For example, you have a living trust, but your house was never deeded into it. When you pass, it goes to probate anyway. You add one child to your checking account for convenience. After your death, they inherit the whole thing, even if your trust says otherwise. You name your trust as the beneficiary of your IRA, but the trust isn't structured for retirement assets. That mistake can trigger extra taxes and penalties. We've seen these kinds of oversights tear families apart, not just legally, but emotionally. Real world consequences. Let me share a few stories from our work at Hackard Law. One client thought her father had left everything to her and her siblings, but an old form gave the life insurance to a woman he dated briefly 15 years earlier. Another family lost time and money trying to reclaim a house that had never been moved into the trust. And more than once, we've seen one sibling inherit an entire bank account simply because their name was on it as a cosigner. These aren't rare events, they're the silent failures that happen when details are overlooked. How to protect your estate plan. So, what can you do? Update your beneficiary designations after a marriage, divorce, birth, death. Review every form. Don't assume they're still right. Retitle your assets properly. A trust only works if your assets are in it. If your home, accounts, or business interests aren't titled correctly, the trust can't help you. Work with an experienced estate attorney. Estate planning isn't just about documents, it's about strategy, alignment, and follow through. Talk to your family, be clear about your intentions. Surprises create suspicion, and suspicion leads to litigation. At Hackard Law, we take the time to walk clients through these steps, not just to protect their plan, but to protect their families. An estate plan is more than paper, it's your legacy. But your legacy is only as strong as the weakest detail. Don't let an old form or a missed step undo everything you worked for. If you have questions, we're here to help. I'm Mike Hackard. Thanks for watching.